Title 4: Extinction of Criminal Liability. Chapter 1: Total Extinction of Criminal Liability. 89. How criminal liability is totally extinguished. Criminal liability is totally extinguished 1. By the death of the convict as to the personal penalties, and as to pecuniary penalties, liability therefore is extinguished only when the death of the offender occurs before final judgment. 2. By service of the sentence. 3. By amnesty, which completely extinguishes the penalty and all its effects. 4. By absolute pardon. 5. By prescription of the crime. 6. By prescription of the penalty. 7. By the marriage of the offended woman, as provided in Article 344 of this Code. See additional modes of extinction under RA number 8353 and PD number 968 as amended by RA number 10707, November 26, 2015. 90. Prescription of crimes. Crimes punishable by death, reclusion perpetua, or reclusion temporal shall prescribe in 20 years. Crimes punishable by other afflictive penalties shall prescribe in 15 years. Those punishable by a correctional penalty shall prescribe in 10 years, with the exception of those punishable by arresto mayor, which shall prescribe in 5 years. The crime of libel or other similar offenses shall prescribe in 1 year. The offenses of oral defamation and slander by deed shall prescribe in 6 months. Light offenses prescribe in 2 months. When the penalty fixed by law is a compound one, the highest penalty shall be made the basis of the application of the rules contained in the first, second, and third paragraphs of this article. 91. Computation of prescription of offenses. The period of prescription shall commence to run from the day on which the crime is discovered by the offended party, the authorities, or their agents, and shall be interrupted by the filing of the complaint or information, and shall commence to run again when such proceedings terminate without the accused being convicted or acquitted, or are unjustifiably stopped for any reason not imputable to him. The term of prescription shall not run when the offender is absent from the Philippine archipelago. 92. When and how penalties prescribe. The penalties imposed by final sentence prescribe as follows. 1. Death and reclusion perpetua in 20 years. 2. Other afflictive penalties in 15 years. 3. Correctional penalties in 10 years, with the exception of the penalty of arresto mayor, which prescribes in 5 years. 4. Light penalties in 1 year. 93. Computation of the prescription of penalties. The period of prescription of penalties shall commence to run from the date when the culprit shall evade the service of his sentence, and it shall be interrupted if the defendant should give himself up, be captured, should go to some foreign country with which this government has no extradition treaty, or should commit any other crime before the expiration of the period of prescription. Chapter 2: Partial Extinction of Criminal Liability. 94. Partial Extinction of Criminal Liability. Criminal liability is extinguished partially 1. By conditional pardon, 2. By commutation of the sentence, and 3. For good conduct allowances which the culprit may earn while he is undergoing preventive imprisonment or serving his sentence. 95. Obligation incurred by a person granted conditional pardon. Any person who has been granted conditional pardon shall incur the obligation of complying strictly with the conditions imposed therein, otherwise his non-compliance with any of the conditions specified shall result in the revocation of the pardon, and the provisions of Article 159 shall be applied to him. 96. Effect of commutation of sentence. The commutation of the original sentence for another of a different length and nature shall have the legal effect of substituting the latter in the place of the former. 97. Allowance for good conduct. The good conduct of any offender qualified for credit for preventive imprisonment pursuant to Article 29 of this Code, or of any convicted prisoner in any penal institution, rehabilitation or detention center, or any other local jail, shall entitle him to the following deductions from the period of his sentence. 1. During the first 2 years of imprisonment, he shall be allowed a deduction of 20 days for each month of good behavior during detention. 2. During the third to the fifth year, inclusive of his imprisonment, he shall be allowed a behavior during detention. until the 10th year inclusive of his imprisonment, he shall be allowed a deduction of 25 days for each month of good behavior during detention. 4. During the 11th and successive years of his imprisonment, he shall be allowed a deduction of 30 days for each month of good behavior during detention. And 5. At any time during the period of imprisonment, he shall be allowed another deduction of 15 days, in addition to numbers 1 to 4 hereof, for each month of study, teaching, or mentoring service time rendered. An appeal by the accused shall not deprive him of entitlement to the above allowances for good conduct. 98. Special time allowance for loyalty. A deduction of one-fifth of the period of his sentence shall be granted to any prisoner who, having evaded his preventive imprisonment or the service of his sentence under the circumstances mentioned in Article 158 of this Code, gives himself up to the authorities within 48 hours following the issuance of a proclamation announcing the passing away of the calamity or catastrophe referred to in said article. A deduction of two-fifths of the period of his sentence shall be granted, in case said prisoner chose to stay in the place of his confinement, notwithstanding the existence of a calamity or catastrophe enumerated in Article 158 of this Code. This article shall apply to any prisoner whether undergoing preventive imprisonment or serving sentence. 99. Who grants time allowances? Whenever lawfully justified, the Director of the Bureau of Corrections, the Chief of the Bureau of Jail Management and Penology, and or the Warden of a provincial, district, municipal, or city jail shall grant allowances for good conduct. Such allowances, once granted, shall not be revoked.